Tracy,
Okay.
Tracy, are
What
you
was
ready
that?
for us to get started?
Yeah, I think that's great if we get started now. I think that this is already being recorded. So I just want to welcome everybody to the Cannabis Orientation Kickoff Meeting. Welcome and thank you for joining us today. We are going to be reviewing the application procedures and guidelines. But before we get started, I just want to introduce you to those who are going to be involved in this program. My name is Yesenia Anderson. I'm your point of contact for the cannabis program. I work for the Director of Community Development, Peter Gilly, who's here with us. Thank you. And also the Assistant City Attorney, Meg Lawrenson, is going to be helping us with this project. From HDL, our consultants here today are David McPherson. Can you wave for everyone, David? Thank you. And then also Matt Eaton. They've been helping us and are going to continue to help us with the review and launch of the applications. So we'll leave it over to David and Matt to go ahead and walk us through the guidelines. It looks like we have about 57 attendees so far, so we're ready to go. Thank you.
Thank you, Yesenia. And as we bring up the applications, just want to kind of re-emphasize a few things on this for those that have never been through this process. Is that it is not the goal or the desire of the city to try to have any gotchas or to find reason to have a problem with your application. So it's going to be important that when in doubt, ask questions, and also to do things on a timely manner for the things that we're going to talk about. Because as technology is, or computers, or things crashing, you know, you run into situations where we just don't want to have to be in a decision to make difficult decisions over things that are beyond our control of logistics. So with that said, there, as Yesenia said, she will be your point of contact to any questions. We encourage you to reach out to her in the email in the procedures if you have any questions. It will be critical that you not reach out to others other than her. We encourage you and be mindful that do not be contacting council members for questions or concerns. Everything should be going through the point of contact, which is Yesenia, on this, not only for consistency, but to make sure there's transparency and that there's no conflict of anyone being disqualified for any nature. As you can see on the application, all this stuff is posted on the website, and if it's not, the rest of the remaining things will be. If you do not see something, please reach out and let staff know that it's not there. Application period 1, there are 2 specific application processes. In the first part of this, which is going to be for the non-coastal area, the process times are on here. I want you to note that it says on the closing, even though it opens June 28th, so you got plenty of time to ask some more additional questions before it actually kicks off. However, when it closes, be mindful of the time. Don't think the city hall closes at 5 or 6 o'clock. If they're not open on certain days or holidays, you need to get it in by that period of time that's on here at the 4 p.m. We've had people in the past, you know, send a staffer with it or FedEx it and they show up at 5 o'clock thinking that that's when City Hall closed, and it's not going to be acceptable. Anything after 4 o'clock on August 11th will not be accepted, and there's nothing that we can do about it. So you need to be mindful of that. As we also mentioned here, for the first part of this, it's unlimited on the wholesale businesses for the current process, but there's only going to be 3 retailers and a total of 10 industrial type permits for that. So I'll correct myself on that, unlimited. So there will be limited on that because we are having a second application process when the Coastal Commission decision is made, which will be in a further date as noted on here. So moving down just to the checklist of things that will be listed on there, looking at the ordinance, there's the regulatory ordinance that's going to, you need to look at and make sure you are familiar with those. If there's anything that's inconsistent with the applications, in the process, look at them and let staff know if there's something that's confusing. That's the chapter for the regulatory, and then chapter 24 has it for the zoning ordinance. So make sure that a property you may be looking at specifically is properly zoned for the type of activities that you are applying for. If you apply for the first part of the application process as well, the question has been, is then can you be eligible for the second one? If you apply for the first one and do not receive a permit, then you would be eligible for the second. However, if you apply for the first one and receive a permit, then you're only allowed to have one permit for the city period related to the retail, not so much on the non-retail activities. That's an unlimited amount of how many you can apply for. So the forms that are on here, look over the forms. We have had on occasion last minute someone asking questions about who needs to sign it, who does it need to include everyone. Can it just be the primary contact on the form? Does it have the property owners need to sign it? Does it have to be notarized? So we encourage you to make sure you read through the forms prior to starting the process as you go. At a minimum, look at all the documentation, even though you're not starting it right away, and make sure that whatever you need, you're going to be able to either get what you need in a timely manner or that you understand questions as you move through this process. Moving down a little more, as we are today in the orientation of the time already stipulated on here, if you know anyone or you have colleagues that you want to have them the opportunity to do this, this is being videotaped, so they'll have an opportunity to review this in the presentation and the orientation. If for some reason you want to go back and look at it, you have it there as well in case there is something contradicting or confusing that we talk about. You'll have the ability to go back and look at that. So all that information is in there. Next page. So amendments to the application. So you need to turn in a complete and accurate application process from the beginning. And Peter, I don't know if we can make this a little bigger for our audience to be able to see it a little better. There we go. Thank you. So in phase one, you do need to submit a complete application of all the required materials. We do have a curing process in here. The goal of the curing process, this in phase one, as it's stated here, is really to look at little things that you may have missed. It's not because you ran out of time and you need to put the security plan or one of the section criteria in it. It's designed more of that curing process is you forgot to get one of the owners to sign a document or the property owner to sign a document, or you forgot to put a date on there. We have experience, and this is important to note, is that when your zoning verification letter, let's say it's 100 Main Street through 102 Main Street, or Unit 2 and Unit B, and your zoning verification letter says one thing, but you fill out the application and only put 100 Main Street on it. You need to make sure whatever addresses or information you put on the application matches what is on the zoning verification letter or any other documentation, so that you do not get a cure letter because you just didn't, make sure everything mapped appropriately. And that's kind of the goal of this curing process. Really, is for those little things. If there's anything that is scored or a criteria that is scored missing, that will be considered an incomplete application. You will be disqualified. However, we're mindful that if you are PDF something, if for example, you have a file that's 30 pages or a document, and page 28 out of 30 documents is missing, that's something that's acceptable, that we would send you a cure letter to saying we're missing page 28 out of this 30-page document. But if you're missing substantial amount, then you could be disqualified for that. So make sure that you look at that very carefully through the process. Moving down a little more. The limitations on the multiple locations. So part of the policy discussion or concern was that we don't want one applicant to be submitting a lot of applications in this process, or people, finding difficulty of trying to have the opportunities for that. So you can see on here that the ownership, even though the ordinance says just defines ownership, and state law is a higher percentage, which is 20%. For the purposes of the applications, if anyone owns 5% or more of the business in which you are applying for, then you have to list them. They will have to be background. And that way we know that the qualifying people are not doing multiple licenses on here, because you are going to be limited to one retail. But again, unlimited amount of applications you can submit to compete for the wholesale or non-retail businesses. So make sure you understand that expectation there and what you need to add on there. When you get to the forms themselves, you'll see that their percentage, if you happen to be a publicly traded company and you just have a board of directors, or you can have thousands of owners of the business, that we will be looking at that 5% or more, or their criteria related to what's in the ordinance. So that currently, just for we're clear that you understand what the city is going to allow and the types of activities, read the ordinance, but it's here as well. You will have retail of both the retail types, the manufacturing, distribution, and testing labs. You will emphasize added there, nothing of any type of cultivation will be permitted. So if you are looking at a micro business, that it will be limited to that, and it specifically shows that when you check the box on the application for the type of business you are applying for. So the city's rights of reservations, if for some reason there's some logistical challenges or there needs to be modification, the city will try to stay on top of posting things and notifying all the applicants so they all have the same opportunity to address whatever modifications that may come out of this. As we get Q&As, staff has received Q&As and have attempted to post those. They may need to be modified. They may be updated. There might be some interpretation changes in there from the city attorney's office, or additional information that's provided to us, that we'll update those. So please randomly make sure that you review all that. But it could be modified, so it's critical that you understand that. The dates, again, re-emphasis on that 4 p.m. August 11th. Can't emphasize it enough, because I know a lot of you put a lot of work into these, spend a lot of money on getting property and resources that, to be 15 minutes late or 30 minutes late due to something, traffic, printer jamming, losing something, just be strategic about, trying to get this in at a timely manner or the day before, so you don't get in that situation, because it's going to occur. The results of non-responsiveness, again, we kind of went over that on the top, but just kind of why you could be rejected in here, and reviewing the 2 applications of anything that might be inconsistent with that. Moving down. So the application process, again, is in conformity with the regulatory ordinance of 6.420. And so depending on the type of activity you're applying for, make sure that you're addressing all those concerns, and which will be in the attachment A in the appendix. Next page. So the application procedures and submittal requirements here, we've kind of broke them down into the buckets of things that should be included in your package. So so there's 2 parts of this to be mindful of. One is you're going to have a full package. So everything that you're going to submit in your package is going to be in a flash drive, in a PDF format. So make sure it is in a PDF format in order to provide that for us. And it's going to be on a flash drive. So that'll be critical, because that's the only total package that we're going to have from you. However, because we need signatures on some of the documents, that you will see also here, so it's not confusing to you why there's wet signatures on that, is a paper hard copy of the documents listed below are only for these documents. So we don't need you to submit a whole package of 200 pages in a hard 3-round binder tabbed. We only need these documents that need to be presented and prepared, so staff will have original documents since their policy requires them to have fresh signatures or wet signatures for these documents, which are all for legal purposes of the documents that you're being required. But again, a full package, which would include these, will be in that flash drive as you're putting something completely in. So when you submit your application, you'll have these documents. It'll be wet signature with a check, and then attached to that will be the flash drive that will be submitted with these documents with the appropriate fees in there. Going down a little bit. So staff is kind of even did a more breakdown for some opportunities for you, because we're kind of still in a little bit in a COVID environment about availability. So you will see that from June 28th to August 11th, you could submit them by mail. Note a postmark will not be accepted timely submission. So, you send it on a Wednesday and it's due on a Friday and it doesn't get there, something happens and delays, especially with COVID. We've seen that packages, even in, overnight deliveries, end up getting 72 hours. Yes, you can go yell at FedEx or UPS, but that's still not going to be acceptable if it doesn't get to the city on time. So make sure you're mindful of that. The other thing is by employment, you can see a smaller window during that period of time for staff being on site. The application back would be delivered in person or by appointment only, and contacting Yesenia, which her email is there to schedule that appointment and make sure that's the arrangement is for that. And then from August 10th and the 11th, which is really the last 48 days, which we know a lot of you are going to take the opportunity to use that time as much as possible, that you can see there's a specific time for drop off that they're going to be available in front of City Hall to have someone there in order to take the applications and accept them from you. So be careful and look at that. We've had someone mix these dates up before when cities have provided this opportunity during COVID, and they transpose those dates or times. So be careful when you look at these dates and times of what you're looking at, so that the one you're trying to anticipate is the right one and in your schedule. And same with your scheduling of time, that you've got that right from the appointment related to that. So on the flash drive, moving now a little more on the flash drive contents itself. So this is really everything that we try to break down, and it will be important that you follow what we're asking for here in each file. And the reason for that is because the reviewers are looking for completeness. And we've had cases where, even though we go through these, if they're not in the proper place, we don't know if you're applying, responding to, the business plan, where the security plan, you happen to put it in there as part of your thing, versus putting in the security plan where it needs to be looked at and you're being scored and evaluated based on that. And it's in the wrong area, and you could be deducted points or disqualified, showing that it's not there when we're asking you for there. So make sure that you look at this through the checklist on each one of the files, and you have the appropriate documents in the appropriate place in here, so that we have that. So responses also is part of that as we go down the PDF files. But before that is the responses pertaining to the backgrounds, proof of capitalization, the zoning verification letter, and the property owner consent forms shall not be included in that 200 pages. We know that some of your financial documents are significantly, could be, a lot more and take up a lot of space. We are recognizing that we don't want that to count against you on your total page count. So those documents are all listed there, which are not listed in that page count, and all of the score criteria. And if you're confused on that, just remember, anything that's going to scoring criteria is the 200 page limitation, and the other items listed here are just things that need to be included in the documents. Some of these documents you will see that'll be in PDF files. So we talk about page 1. If you look at the financial responsibility forms, you'll see where it says page F1 through F3, and then you'll see where the indemnification and warranties is F4 through F6, because those are documents that are on the same PDF printout when you print that as a kind of a 6-pager of 2 different documents within that document that we're putting together for you. The next page. I'm sorry, down. Oh, sorry about that. So PDF file 2, the valuation criteria. This is what is listed in the appendix in response to the section A through H, which is all the categories that we talked about, the limited page count. That will be all in there because that'll make it easier for staff to review for the completeness. When the evaluators go and look at the application, they're looking right for that, and they don't have to go through other documents pertaining to that, since it will be done probably separately from who's looking at it for a complete application that needs to be in there. So again, make sure you go through each one of the files and what you're expecting falls in there. Sections A through H in file 2, the background and all the other documentations associated with that, with the receipts. So when you go on the receipts, are going to those that have never been on the portal link, when you click on it, it's going to ask you to fill the information on it. And then when you make the payment associated with that for the background, it's going to print you a confirmation for the receipt. That is what needs to be submitted with the package, is that receipt or confirmation in file number 3. And you make sure that every person has that the application. Any scanned documents related to that is in that, related to that. You will not get a scanned printout of the application that you submit, because it's all done online, just the receipts for that for each individual.
Dave, I want to make a comment about the background.
Please do, Matt.
Please be aware that our system has a fraud alert built into it. If you are going to be applying for multiple backgrounds and you want to do it on the same credit card, the system will only allow you to process that credit card about 3 times in a 24-hour period. If everyone is doing their own individual, then it doesn't matter. It makes no difference. But if you are going to pay for all the backgrounds on one credit card, you'll have to spread them out, because the system will think that the multiple use of that credit card is fraud, and it will lock that credit card out. And it oftentimes, if it locks it out for like a week period. So if that happens, please contact us, let us know. But I do ask that you be very mindful. Try, if you're going to do one credit card, do only 3 at a time, and then wait a 24-hour period. Thank you.
Thank you, Matt. So again, I emphasize that. So if you got 6 owners that you need to put on there, you do a maximum of 3, then put on your calendar to do the next 3 the next day, or so that you don't run into that problem. Okay. And along with that, if you run into any problems on the background related to the portal link or anything, feel free to reach out to Yesenia, and she will forward email, and we will contact the individual regarding the concern or issue, or if something is confusing to them. So with the fees, moving down, looking at our fees now. I'm sorry, let me get that. So let me finish the PDF files, Peter, there. So again, you can see through the breakdown, each one of the different categories, the file 4 is proof of capitalization, and the bank statements, and anything related to that. So when it comes to the capitalization, it's going to be very important that you demonstrate that has your connection. So if it's a loan from a bank or a loan from a third party, that it's not just a letter, there's evidence of the proper funding for that we could validate the source document. If it comes from a bank, it's less of an issue, But if it doesn't come from a financial institution, just a letter from, a good friend that wants to say, hey, I'm going to lend Joe Smith, $500,000 or, $200,000 or $50,000 for the project. It's got to be on a letterhead. It's got to be something that we can substantiate. If we have to follow up on any of those documents and ask you for that, so we can validate that there's legitimate funding there, it's going to be critical that whatever you're showing us is going to be something that we're going to accept and acknowledge. If not, then we're going to ask those questions for you. The burden is you to demonstrate that. If it's a bank account, you can redact, a confidential account number or something, but we're going to need to see the name of the individual or the business entity that's lending you the money, and that it needs to be a fairly current document related. We don't something from a year ago or something. It's got to be something fairly current on that. May I ask Matt, do you want to expand on that a little bit?
Yes, current would be anything less than 6 months. Obviously, the more recent, the better. But anything beyond 6 months, we would not consider current.
Thank you, Matt. And then the zoning verification letter, as we mentioned to you, is going to be separate. And when we look at the fees below, you'll know that it's going to be something you have to go in and take care of with the community development department. They have a letter that we've worked with them on establishing just the criteria and the sensitive uses and other things that are there in the zoning. That letter will need to be attached in there, because the evaluator is just going to be looking at that letter's in there. But also more importantly in that is that we are only accepting 2 zoning verification letters per property for retail. Again, only 2 zoning verification letters per property. And when you come in with that, you will have to show evidence that you have either you own the property, you've got a lease agreement with the property owner, or a letter of intent that has been approved by the property owner. And once the city receives 2 of them, they will no longer accept any more zoning verification letters for that property for retail, and that's specifically for retail, to limit that number on each property, because that's the primary concern here. So now as we move down to the fees, so this is set up and designed to try to capture the 3 sets of the initial fees for phase 1 and 2, assuming that most people will get that, for very limited those that would not, so that you will be paying the initial deposit of that dollar amount, $8,844, to cover those 3 first phases, to cover the costs that's already been developed through the analysis. And then if you continue moving through the process, then you will be advised that you will need additional funds to be deposited for the remaining process. You will also notice that there are some additional fees for the breakdown of just the specifics. And the reason that it has to be broken down is, for example, the background check is the provisional background that we're going to do on our website, but then we have to do the live scan later as part of that process, and that's a state fee that's broken in there. We just consolidated in there, and then the staff times already had a cost associated with what they do with zoning verification letters that is identified there, because it could take a significant amount of research on some of these, and that's their cost associated with that. Not knowing how many owners we're going to have for each property owner, not knowing if you're going to submit more than one zoning verification letter for addition, multiple properties that you may be looking at it. That's the reason why they have to be a separate unit cost fee related to that. As I mentioned, that as you move through the process, there may be additional fees. The other key thing right here, especially because we're still in that COVID type environment, is that the city, the payments must be made by certified check, cashier's check, or money order. No cash will be accepted, or a credit card during this process. Moving on to the criminal history check. So as we shared for you, again, look at what meets the definition in the ordinance for who needs to be bound on here. And then if anyone that meets that criteria is part of your team that needs to be background, the link here for the background is on the website. So you can get there and do it. As we talked about already, the breakdown of the payment, be cautious about the maximum of 3 per time or per day that Matt had presented. Okay, we're back. So the process will be on this, is so we'll start the provisional background component of this, and it'll be part of the package, as we said, with that you have to submit. If anyone is disqualified due to that, you'll be notified during that period of time of the package being submitted, and then we can address the concerns on there. Should there be something of question of concern, it's better to be safe to put something on there than omitting that. And I'd like to make sure, Matt, you want to expand on that a little bit regarding some couple of situations.
Yeah, thank you, Dave. Make sure that you include all appropriate responses, i.e. arrest. We have found that people omit or leave out things that are otherwise non-disqualifiers, but the failure to disclose that, our background does find all of those things. You are much better to disclose those. And if they are non-disqualifiers, there's not a problem, we indicate that. But the mere fact that there would be a non-disclosure, it shows untruthfulness. If there is a non-disqualifier, we flag it, we will give it to the city, and then that individual will be called in and that matter will be addressed on a one-to-one basis outside of this application, the other application process. And then a decision would be made on how to handle that particular background. So please be aware, please respond completely and thoroughly to all requests, even though it might not be a disqualifier. It would be a problem if you omit the information.
And if you have participated in other application process, sometimes there are cities that will say only the last 7 years or last 10 years. That is not the case in here. And part of that is now as we move forward and we get farther away from the initial regulations of 64 occurring, is that the state has no limitations on the time limit. So it's important that you not think, oh, it hasn't happened in, I suppose 7 years ago or 20 years ago or 10 years ago. It's immaterial on this. You need to make sure you put anything on there to reflect that. Okay, moving down to the next page. Actually looking at the phases now. So in the phases here, as we mentioned to you, the termination of eligibility in phase 1 really is, did you put a complete package? Did you meet all the compliance requirements, the minimums that we needed to have in here? Did you put everything that needs to be in there in the procedures that were adopted? Did you follow the instructions on there? Did you look at any of the clarifications? So if there was something vague or inconsistent and there's an update on the Q&As to respond to something, then you need to make sure that you follow that in the process. The Q&As, as we get questions, for example, staff will get an email related to an issue regarding something, and they will not necessarily respond to you directly. They might then take that question and post it on the Q&A, or they might respond to you directly, but then it'll also get posted on the Q&A so that everyone's getting the same information. Even though it may not pertain to you, we want to make sure everyone's getting a response, because it'll be a question you didn't ask, but you might have, or it triggered something. So we want to make sure everyone's getting the same information and no one's being treated more responsive to things than you are, everyone will have the same information or presented the same responses as the person asking the question. So again, make sure that package is complete. We went through the different files related to how that should look, following the instructions on the any additional Q&As on there. Looking at phase 2 with the criteria evaluation and scoring. This is because we are limited in the number of permits, especially on the retail, to 3 and 10 for the non-wholesales of the total at this time, is that there's more permits and more applicants than there are permits, and this is a competitive merit-based process where it has to go through that and looking at the termination of this. So the criteria, Peter, if you can just move it a little higher on the, you can see the criteria. So as you can see here, it's broken down in 2 different categories. In phase 2, this is more technical in nature. So the appendix will break down what needs to be included in there. If it's not clear, then ask questions specific to that. You will need to receive a 90% or higher. The top applicants is determined by the score of a minimum of 90%. And this is important because the city doesn't know how many applications they're going to receive. They can receive 5 or they can receive 40. We don't know yet, or more. So the minimum is 90%, but just because you get 90%, it doesn't mean that you're going to move on to the application process, because the city manager has not made that determination yet. So you will see on your is that then that based on the decision will be made on the number of applicants based on the numbers and the quality of those numbers, that they will make a determination of how many people will be interviewed associated with that. With that said, looking at the appendix again, phase 2 is technical in nature from sections A, B, C, and D. The points in there are broken down per category, so it doesn't max out more than what's in that specific category. And so you need to make sure if you have any question, what it includes is looking at the appendix, ask questions to staff. In phase 3, further evaluation, this is the interview process. So the evaluator is looking at the written part. Phase 3 is the interview process only. They will have the scores and results of phase 2 to take in consideration to review your responses to questions. But during phase 3, it will be a staff selected committee that will be doing an interview, and they will be looking at sections E, F, G, and H, which is more of the subjective component versus the technical side of it, and how you respond specifically to these categories, and examining how they look at that from your responses to the questions that will be prepared for that purpose. Once that is done and the city manager's designees tabulates the scores and they make that determination of who is going to move on in that final ranking, then there will be a public meeting. So similar like a CUP process, but not a CUP process. This is a public meeting where those top applicants will be invited to a meeting that will be consolidated so that the community can put their input to this still to address any questions associated with your application or your location or any other nature. It doesn't mean that everyone that does not like to support cannabis coming into the community will be addressed, but there will be specific questions that could be a concern of the total package or location that staff will be reviewing, take notes, and provide recommendations or the results of that public meeting provided to the city manager or their designee to make that final recommendation. So when that occurs, they will have that information. When the score is being done, so let's say somebody, the city selects a number. Let's say, for example, that cutoff line, wherever it's going to be, is let's say 95%, right, of the total numbers, because it's very, very, very competitive. And you have 2 people that get 95% or 95.5%. At that point, depending on the number they look, they'll have to look at that number, but they're also going to force rank those to say, wow, we're only going to take the top 5 or top 10 to this process, and they got to define who is number 5 or number 6 or who's number 10 and who's number 11. Then they will force rank those to determine that number. Once that evaluation is done, determine who is going to move on in that part of the process to make it easier. So it's not going to be all about just the percentage in itself, but that will be part of the consideration of there. And once they move that along, then they move to phase 4, moving on to the next page. So at that time, on phase 4, the city manager will sit down with the staff with their final recommendation reports and feedbacks. They may ask questions related to comments made for research, validations, red flag some questions. They might reach back out to you, get some additional information from you, address a certain specific question or something that may be brought up that they need to do their due diligence on. But somewhere to this point, we have not been able to, or staff has not been able to even contemplate it because it was not something that was identified at the time. This provides the city manager an opportunity to reevaluate all that before he or she makes that final decision before who they are going to recommend awarding the permit at that process. So when that decision is finally made and everyone's notified of where they're at, and again, the appeal process is listed in the ordinance, so look at that carefully depending on where you are in the process if you're going to potentially want to appeal the decision made. So you'll know your timelines associated with that. But for here, when those are done, and they're done at different steps, possibly there, then it specifically tells you your opportunity and time to make that appeal once you receive that notice that you're not moving on, and it will be done by a hearing officer that's independent from this process and helping in that decision to see if your appeal is something that needs to be reevaluated in a decision to move you forward or continue in the process. And we talked about the zoning verification letter and some detail in here, kind of explains of where to go, what it is. It's not going to be done over the counter. Again, be mindful of your time due to the volume that they may be receiving, that don't try to jump in there 3 days before this needs to be shut down. They have them verify your zoning verification letter. Just because you've negotiated a letter of intent or a lease and you were executing that, you may want to at least be mindful of moving this along earlier. And so if you are having challenges with getting something negotiated with the property owner, you may want to work with whatever document is going to get you in the door a little sooner to the community development director in order to at least get this process done so that it can be done timely and taking that in consideration. And then just a note here, this doesn't follow the Permitting Streaming Act because it's kind of not follows the same requirements for that. So as you move through this, that it will have different restrictions. I mean, it will have different criteria associated with that. On the proof of insurance, so if you currently have retail locations other places, we are requiring you to show proof of insurance or demonstrate a letter that you can be insurable. And what we mean from this, we recognize that you are, you go to an insurance agency and you say, hey, I need an insurance certificate for, to do a retail and a distribution. And he goes, there's a lot of data they need in order to figure out what your insurance. They go, well, I have no idea what you are. You don't have a permit. I don't know the specifics. I can't give you a quote for insurance, or I can't provide you an insurance. Then you just need to get a letter that you're insurable and that is specific to the location, specific to the type of activity you're applying for. And we've ran into a couple of challenges where somebody says, hey, I got a location down the street, and I make a copy of that certificate and I submit it into my application because it has your name, your business name on it, and for the activity. That won't work. You will need to have it specifically show 300 Main Street, City of Ventura, or retail and distribution, if that's as the example I'm using, or the letter needs to specify that you are insurable with the letterhead of the insurance company for the activity you are doing. And then later, should you be awarded the permit, then you must show evidence of that prior to getting the permit. We recognize that that's been a challenge when just requiring something that's not there yet. So read that a little. If you have questions, reach out to staff. Moving down to page 7, then the land use permit. Again, this just kind of goes into detail that, you know, if you get awarded a permit, congratulations, you got your regulatory permit. It's only on the regulatory permit where you are being awarded it conditionally. And it's going to emphasis added on conditional because you are subject to getting your land use permits requirements as you would for any other business in the city. You have to get your land use and building permit process. If you can't get through that process, then just because you were awarded one, it doesn't mean that you've got a license or a permit until it is subject to you complying with Chapter 24 in the building code and the planning requirements for the zoning and fire inspections and building inspections and planning review. So look at that, get along far enough in that process when the time comes. Don't think you're done and automatically, you know, you're in, because that's half the battle, as many of you that have experienced that are aware of that. And then here's Yesenia's contact information specifically for her, should you have any questions for the city of any part, and then they will work with the appropriate staff, being it the planning department, be it with us as HDL or the attorney's office, whatever. They'll review it and try to get the appropriate answer for you in a timely manner. So moving on to the appendix. So one thing up here you will see on the top of here is, and no surprises to most people, is that all your documents are subject to public records disclosure for the most part. There are confidential rules to the government code associated with that, and the city will do their best to be able to redact information or any information asked that is confidential in nature. If it's something specific that it's either proprietary or financial documentation or confidential that meets and complies with government code for that component of it, will do their best to do there, and they will notify you. So there'll be such or do their best to notify you should someone ask for information of any application or all applications that might go through this process when the time comes through that. So be careful on there. If you've got information, if you want to make a note there, this is proprietary information, or this is confidential, that helps guide staff through when they're looking at that to determine, you know, something to red flag. It doesn't necessarily mean automatically that it won't be subject to the CPRA Act. However, it will at least flag them to be cautious that they should be look at it a little more carefully when the time comes. So as we move through the sections here, the first one is the business plan through this appendix. And the criteria, as we said, put everything in the appropriate place, know how the sections are scored and the elements of there, that you cover all the checklists with this through what we're asking for associated with that. Make sure you look at the information of each category and respond to that and clearly define where that's at. We have it broken up on describe the day-to-day operations for each category. So each one has their uniqueness. Don't try to boilerplate it for, you know, multiple categories. Each category, if you're applying for something, needs to specifically address some of the variations that are in here when putting this business plan together. You know, and this can be a very competitive process. A few points here and a few points here can be a big separation on that. So you don't want to lose points where you weren't clear on something on some of those requirements in here. Matt, did you want to comment on anything on here as we go through this?
Yeah, thanks, Dave. So it does appear sometimes that the question is redundant. It is very important that you respond to each and every criteria in each of the sections. Even though it might be redundant, don't say refer to section 1 of the business plan. We need to see you explain it. There's a reason for that. One of the biggest problems is you putting the information in the wrong section and not being awarded or receiving the appropriate amount of points for that. So even though it looks redundant, it does need to be explained. I do also ask that if you have a very complicated financing structure, your proof of capitalization or your corporate structure, it is beneficial for you in this first section, in section A, to provide a narrative explaining the corporate structure and the financing. So the better we understand it, the better and easier it is for us to award the appropriate points. So please, if you have a very complicated structure, take a little extra time and narrate that or outline how it is so we understand it.
And as emphasized earlier, remember the proof of capitalization amount says about expansion on that. It doesn't count toward your 200 pages. So being able to elaborate that without trying to say, well, you know, I don't want to use, 15 pages of something. I want to use 2 because I need those pages somewhere else. It doesn't count towards that. So it shouldn't be a problem with you. And that's the reason why we have that. We recognize that there's different levels of that capitalization information. So as we move through this again, 2.1 through, if you can move up, Peter, you'll see again that each permit type you're applying for has a specific different grouping in there. And so they're all uniquely, some of them are specific to that category that only complies with state law, but also complies with the city ordinance, but additional information that we're asking in there to kind of evaluate that too, as we look at your location, the type of activity you are incorporating in it. So we keep moving through there, Peter, to page 9. So when you manufacturing and distribution, where's micro business? So if we can move down to the micro business one. So there's, because of the facts, you'll see where we've just reiterated again, if you're doing the retail, distribution, and manufacturing, we're asking you for each section of the criteria, just as if you were looking at the criteria above for each category, if you're doing them independently. But because micro business, as those that know where micro business, functionality are, even though they're separate type of activities, there's a unique requirements because you're under one roof, one business, and you need to demonstrate that understanding, acknowledgement of how that all blends together for that process. So moving down to section B on the labor diversity and inclusion plan. So the applications, looking at it, we're really trying to look at, identify really how you approach this, and everyone's going to be different in how that is, but there's some common areas that we're looking at in the as a policy. For those that have been following along with council discussion and concerns, that there's certain things that they would like to see associated with that. And this criteria kind of addresses that, but this is just the beginning of that, right? There's things that are going to be specific to yours because of your mission statements, how you address things, how you look at things, how you bring your workforce together, your ownership, and some of your mission statement stuff. All this kind of covers into there and how you're going to present that. And there's no just one look fits all. But at the end of the day, be mindful of the specific categories that are listed on here as a minimum. And the stronger you define that and explain that will be, obviously stronger to maximize the points associated with that. Moving on to page 10 on section C is the safety plan. And I'm going to ask Matt if he can talk about specifically for section C and D and the difference between what we're looking for here and common mistakes.
Thank you, Dave. The section C and section D are 2 separate plans. Please make sure in your application that you ensure that they are separate so we can review and award the points appropriately. The mistake that we see oftentimes is that you will merge them together, and in doing so, you end up inadvertently leaving a lot of detail out. The safety plan is designed for just that, the safety components of your operation, and that needs to be prepared by a professional consultant. If you can have the same consultant for both sections, but please indicate that in your application. Don't leave it to us to assume that if you didn't include any detail in the security plan, that it was the same consultant. Please make sure to indicate it individually. The safety plan, if you were to go 1, 2, 3, and 4 and describe all that detail, that's what we need for that plan. The security plan is where the diagrams fall in, and what we need you to do, we will go, when we do the evaluation, we will go section by section or subcategory by subcategory, checking to see if you have all the detail that is required. And again, the biggest mistake that people make is merging those two together or kind of blurring the lines and putting the wrong information in each section. So just make sure that when you're responding to the safety section, you respond directly to those questions or those criterias, and then the same when doing responding to the security section.
And with that said, a common question that we get in their Q&As related to this is, well, we have our own consultants, so why do I have to hire a professional? And so, Matt, can you expand on that or what we're looking for or to address that question?
So if you have your own consultant and that consultant is a professionally paid and qualified consultant, you can use your own consultant. You will need to give us some type of criteria or explanation of what makes him qualified. The state has some very specific qualifications for fire safety, fire suppression consultants. There is not a clear definition of what a qualified security consultant is. The state has security licenses, but that really applies to people that are working as a security guard and not necessarily security system installation, things like that. So if you are a larger company and you have your own in-house consultant, give us a little explanation or his background, his qualifications, his or her, and we will accept that. But if you just say we have an in-house person and don't give us any qualifications or don't list out some training and experience, then you will receive a deduction in points for that.
Thank you, Matt. So moving along through that, looking at section E, the qualifications of owners. It comes in different ways of how we're looking at that, examine to demonstrate that. And exactly what it just says here, demonstrate the business owner's experience in owning, managing, operating a retail cannabis business. And, you know, from where they're at, and this is in the legal and lawful world, we're looking at, and meets the definitions of what an owner means by what we've here in Business Professions Code, and includes all persons, companies, and we'll go to the next page, and entities that will be directing, controlling, or managing the day-to-day operations. Evidence that prior experience was from a legal permitted activity. So again, that definition, because of some of you, could be very big. So, you know, we're looking at the totality of each one of the individuals and qualify them to make you, you know, the probability is everyone's going to meet a certain level of qualification, but what is going to really excel that into that or demonstrate that to sufficiently demonstrate that is going to be important that you clearly define that. Same with the knowledge of understanding the industry, and we hear a lot that I understand what that is, but regulator world, it's important that you understand and demonstrate that to us, because that's what the evaluators will be looking at, and that has to do not only regulations but best practices and how you present things for specifically for the city of Ventura, which could be unique to others, where if you're out of state or come from a different area or do things differently, it's got to be clear that you understand what they're asking for and looking for there. And then, who's involved with the ownership of the team on a day-to-day operation. That will be important to look at when, again, looking at the definition of who the owner is. So Section F is the neighborhood compatibility. We recognize, and this is a policy thing for those who've been following it, is that the council is very sensitive to this, of addressing where your location is going to be. Everyone is going to have different uniquenesses of where they're at. If they're downtown or commercial corridor, coastal zone when the time comes, Main Street, non-main streets. Every one of those are going to have a different look at this. It's going to be important that you well-define addressing the neighborhood compatibility ones. Council has specifically concern regarding access to youth. So if you are in a location or even consideration of a location of the sensitive buffers, not only what sensitive buffers that you're close to, but also the impact of the walking of where the youth access could be exposed to your business. So you're going to really need to demonstrate to in your proposal, as listed here in 5C, and I emphasize this because this is critical of a policy direction. There's been multiple conversations by the city council over this. List any nearby well-traveled paths to schools and describe how the cannabis business will be proactively protect the youth on these paths from exposure to the cannabis business. And this is not just the path itself, but it's anything that can impact those youths of addressing, seeing your business, walking by your business, hearing your business, anything associated with that you think is going to be critical. But also, if you've been following the city council, there are concerns associated with that, because to be able to get to this competitive process, which will be very competitive with the limited numbers, you're going to have to demonstrate in your written work, your interview, the public hearing, and also the city manager and his final determination regarding the outcome of all those in order to be successfully get an opportunity to get a permit. So we can't emphasize that enough, because it has been a very sensitive issue with the council. So do not underestimate the impacts of that as part of your decision of what you strategically are doing for that. Everything else here, follow and be mindful of. I think they're pretty much well defined of what we're trying to address here. And as Matt said, is some things could be redundant in various categories. And this one you might say, well, I covered that up there, so I'm not. You need to be addressing it appropriately here too. So moving to the next section in G. So section G in the community investment and investment plans. Council will have more conversation regarding the outcome of what this is. For those that don't know, the city does have a cannabis tax. So there will be a tax imposed for the various types of activities, which is part, you can look on that, or what the rates are going to be if you're trying to look at what you're trying to put together for your business model for community benefits. But looking at it from, a broad ways of getting there, as it says here, and I'll just read that the cannabis business should describe benefits the business will provide to the local community. For example, by directly aiding, participating in, or funding the work of local nonprofits, community-based organizations, civic organizations, or social service organizations. Benefits may be in the form of volunteer services, monetary donations, financial support, or city-sponsored activities organizations. in-kind donations to the city or other charitable or other economic incentives. So again, we have in there other economic incentives to the city. So even though it has a tax, you might provide some other things, again, in a very competitive process. How you put this package together and present it strategically is going to be, put you in a position how you're going to have to figure out how it's going to be favorable to you to best position yourself for the type of activities that you're addressing, and for the things that that are important through this process. Have you done research of how you want to approach this? Moving to page 12, and the last one, in proposed location. So again, kind of as Matt said, some of this is redundantly, but has a different slide approach to the question or what we're looking for there. So your specific location, just like the neighbor compatibility, is going to be unique of what we're looking for there, but also the proposed location of addressing these things to bring that out as well. This is focusing on different things in section H, which section G is looking at other things similar to the same location, but for different things. So make sure that you are specific here. And Matt, do you have any comments related to this as well?
I do. This is that section I was talking about. I want to make sure that it's clear that when responding to the security diagram, or I'm sorry, when responding to the security plan and including the diagram, that diagram is really to focus on, the primary focus is on the interior, the layout, the names of the rooms, identifying the limited access areas, identifying the camera locations, and all of those items that are listed under 5006 of the Bureau of Cannabis Control rules, and similar or like sections for other regulatory bodies. But in this section here, the proposed location, this is designed to address the outside. Don't give us the same exact plan and detail the inside. Now we want to see the outside. We want to see the parking spaces in the driveway, the pedestrian right-of-ways, and how it interacts with the business. So this plan here needs to be focused on the outside or the actual property. And the security plan is to be focused on the floor plan or the inside or the actual licensed premise that you will be operating in and securing. So this is one of those sections. I don't want you to think that it said diagram and you're going to put the same exact one, because if you put the same exact diagram for both, you're going to end up losing points. Thank you.
Thank you, man. So I think that's at the end. I think that's the end on here. So at this time, I don't know how Peter, if we have questions, I think it's going to be important for us to be able to answer any questions that we may have. If we cannot answer questions, then we will circle back with you and put it on the Q&A and provide you a response. So
it looks
I'll
like
turn it up to you.
Yeah, the chat feature was just opened up. So at this time, everybody should be able to use that feature. If you have questions, go ahead and enter them into the chat and we'll just take them as they come.
Okay.
So I have a Greg Conway that has 3 questions. Greg, I'm going to go ahead and unmute you and you can ask your questions. Okay, Greg,
Perfect.
you are unmuted.
Thank you. So the first question is related to the local residency. So it states that the person, if there is a local resident on the application as an owner, they have to have resided there prior to November 1st, 2019, and or a year before the application is submitted. So theoretically, if someone lived in the city in May 2020, that's over a year, but it doesn't meet the requirement of November 1st, 2019. So I was curious as to what exactly that meant and how that was defined.
So the ordinance, being adopted, there was a moving target on here. So I'm going to see if Megan wants to chime in on this response.
I'm sorry, can you repeat the question?
Yeah, let me find the exact language. 1 second. Right. So it's section B, number 8. In order to qualify for this criteria, which is the local resident criteria, an owner must have lived in the city of Ventura for at least 1 year and or before November 1st, 2019. So that and or is a little confusing. So if someone has lived in Ventura since May 2020, currently that would be 1 year. But then it says and or before November 1st, 2019, which is over 1 year. So I want to get a little bit of clarity on what that meant.
I think we will ultimately need to provide some clarification in the written document as to what that means. We need to have some internal conversations about that, and we can provide an update on the website for you.
Okay, yeah, because it seems a little contradictory at the moment. Second question was related to training. So the criteria mentions training in 3 different spaces, and the training is all very specific to those spaces. So there's odor control training, there's security training, and then there's continuing education and training. So if we wanted to discuss in our application overall training, just as it relates to customer procedures and compliance with regulations, where would that piece of it fit? Where would the appropriate section be to address the comprehensive training that employees are going to get?
Matt, you want to respond to that?
A good question, and thank you. So the goal is to try to respond to each criteria as it's laid out. If you have kind of an all-encompassing issue like this, at the end of the business plan section, if you put a header of training and then explain that there will be the following specific training for these areas, then as long as it's in that narrative is in the business plan section, we will award the points appropriately.
Okay, that's helpful. Thank you. Last question is, in previous cities over the last year, there's been a little bit of hesitancy and somewhat of what I would equate to a gag order on community benefit organizations being able to be listed in the application. So for instance, if we reach out to a homeless shelter or an animal rescue or whatever it happens to may be, and ask them if we're allowed to list them on the application, there's been instances of the city saying you cannot list specific organizations or specific people that you're going to work with in your community benefits section, as it might influence the outcome. Is that something that the city of Ventura thinks they may institute? Does that question make sense, or should I rephrase it?
Yeah,
no. This is Matt. Anytime that has been a problem in other jurisdictions, it was a matter of concern with regards to 1 or 2 very specific organizations at their request. I do not know at this time that there is any type of request such as that. But what we will do is we will speak and be able to respond specifically in our FAQ.
Okay, thank you.
Mr. Conway, oh, it looks like you are finished. Okay. Our next speaker is Courtney Karen. Thank you. Courtney, you're
Hi,
unmuted.
my question is just what amount of points is being given for the local owner 51% ownership section of the application?
So the breakdown for the different categories is not defined specifically for of evaluating the total section. So at this time, we would not be providing that to that detail.
I mean, I think this is something that the city should probably discuss, because if, for example, it's worth 20% of that section, then there are probably applicants who will not apply if they don't have a 51% owner, because they know that it will be near impossible to hit that 90% of the points in order to move on to the next round. So it seems pretty unfair to have a requirement of a 51% ownership and then not to clarify for applicants how much of the application that's going to be worth, knowing that the final scores in these application merit-based processes typically come down to 1 point, half a point, a quarter of a point between applicants. I would use Oxnard as an example of this. So I would ask that the city reconsider providing information on what that specific category would be worth, as I do believe that it would narrow down considerably the number of applications that are received.
And I think we could have an internal conversation with staff about that and provide a response of where to address your concern regarding encouraging or discouraging people from there. So we'll put that in the Q&A as well.
Surely appreciate it. Thanks so much.
Thank you.
Our next speaker will be Sam Kojak. Sam, you're unmuted.
Thank you. Had mentioned that there's a micro business in the application, but with the city, it only shows there's 3 licenses for retail. Has that changed, or is that going to be revised? Just wanted to get some clarity on the micro business versus the retail.
So the way the application in the narrative on top says that a micro business or retail. So if you have any retail activity, and in this case, because you can't do cultivation, it automatically triggers that a micro business will include retail. So if it wishes to, for example, award 3 retail permits and you apply as a micro business for that, then that would be awarded one of the 3 permits for the micro. The micro business would be awarded one of the 3 retail permits.
Thank you.
The next speaker will be Ginger Gomez. Ginger, you're unmuted.
Hi, this is actually Jessica. I'm a consultant and she's my project manager. I wanted to ask several questions. I understand you guys have hard and soft buffers, but in the application guidelines, it's not very clear as to how the point system works for soft buffers. So that's my first question. The second question is, let's say there's a part-time chess club within the vicinity of a location, and there's about 10 kids who meet 3 times a week. Would that be considered a youth center if they're just only renting a unit within a building that is a majority, let's say, another use? And then the other question is, we've had a little bit of a hard time. I know Yesenia is a woman on high demand. So I wanted to know, and I'm sure she's getting like thousands of emails a day. What is the best way we could consolidate our questions and make sure that and Yesenia, I'm sure you're listening. What's the best way to reach you and not overwhelm you, but get a timely answer? Because I know that you're having to work with so many applicants.
I can just go ahead and start with that one. I do think that the email address is best. If you can consolidate, like you said, all of your questions and send into one email, then I can take those and, as David explained before, share a reply, but also post those onto the FAQ. So email, even over phone calls, is the easiest. And as you mentioned, consolidating the questions would be the best way. Thank you.
Thank you so much. And also, let's say again, to my soft buffer question about the, let's say, part-time chess club, let's say if they're licensed versus unlicensed, does that count as well? And then that's the end of my questions. Thank you.
So if you look at the definition of a youth center and what it entails, it's primary use. Youth center means any public or private facility that is primary used to host recreational or social activities for minors. So if it's not its primary use, and as that, I think that's the examination, for clarity on there, but typically it's that it's primary use and it's used a majority of the time for that facility. It's not like 2 months of the year. But I think to give Megan an opportunity to expand on that for clarity, we could put that in the Q&A for how you address that specific issue. Unless Megan, you want to chime in on that.
No, I do think that we should put a response to this in the Q&A.
Yep. Okay, thank you.
Okay, our next speaker is Lauren Fontaine. Lauren, you're unmuted.
Hi. So I guess I think my question was already clarified. I was asking about the local preference criteria that was in section B. And someone else then commented that it required 51% ownership. So I would just reiterate the comment from the earlier person about the city clarifying how much points that's worth, so that it's clear to applicants if this is like almost a requirement, because you won't be able to get a competitive score without the local owner, or how that will be weighted by the city.
Yep, noted.
The next speaker is Eric Murray. Eric, you are unmuted.
Great, thank you. I appreciate you guys hosting this session and Q&A. So question is regarding sensitive use buffers. The city has provided the ArcGIS map. To what extent can we rely on for the hard buffers? I know the soft buffers are much more difficult, but for the hard buffers on the 600 feet from schools, can we rely on only that map, or is there a duty of additional investigation for schools that may not be on that map? Can we consider the ArcGIS as the definitive source of hard buffers, is the question.
Peter, do you want to respond to that?
I think it's probably, I was hoping it would come from Meg.
Oh, okay.
Yeah. I would advise that it is a useful tool to kind of look at the buffer zones. But the only thing that you can definitively rely on is the zoning verification letter. So once planning is able to go through the extensive check to determine whether or not it is actually within a 600-foot or outside of that 600-foot buffer zone.
Gotcha. So then we can actually, I know that there's a 10-day turnaround, but tomorrow, effectively, we could go ahead and submit and ask planning for that ZVL. And then 10 days later, once we get that ZVL, is that then the hard buffer definitive document?
Yes.
Perfect. Thank you, Meg.
Next is Cassie Bowen. Cassie, you're unmuted.
Thank you. Hi, so my question is about the zoning map also. I'm looking at M1, M2, and I noticed in the regulations there was also an M3, but on the zoning district map, there's M1, M2, and then MPD. So I was just wondering about the M3 designation.
Can you tell us which document you sent the M3 in?
Yeah, actually it was in the zoning regulations. There was a spreadsheet that listed different cannabis activity. You know what, I might just need to pull it up and send it over to Yesenia as an email if no one knows what I'm talking about. So is there M1 and M2 only then? And MPD?
We'll verify that and put it on the FAQ. My understanding is those were the 3 districts that were available for the manufacturing uses.
So no M3?
Yes, we don't have an M3.
Okay, perfect. All right, thank you. I appreciate it.
Next is Vince Halleck. Vince, you're unmuted.
Hi, I was asking to see if, my main question is on applying 2 applications to 1 property. Being that it's a merit-based application, what is the process if both applicants score in the top percentages? Are one of them able to then move their application or permit to a different property at that time?
Megan, you want me to respond to this, or do you want to chime in on this?
You can take it, David.
Okay. So, that is the challenge that you as an applicant take the risk of. Because if the requirement is it's 1 per property being awarded, making that decision to compete with a property where you could end up, let's say, number 1 and they end up, or someone ends up number 1 and you end up number 3, the city manager then, goes through that whole process to evaluate it. But the complexity is that the decision to award you or score you to that level is based on that location. The neighborhood compatibility and the location criteria is specific to that, where if you would have been on a different property, you may have had a different outcome of your score. So at this time, if that ends up being the case, then the city manager has to make that determination of awarding only 1 permit for that property, since only 1 can be on each property.
Understood. Thank you for that. I also have one other question. I'm sorry, 2 other questions. Is there going to be a rubric for the scoring system? And also the requirement of the local, I believe you guys went over this, I'm just not sure 100%. If you guys stated that it was a 51% ownership for local?
So the definition of 1% ownership is for the purposes of local ownership to get points awarded to it. So you can't come in at 40% or 20% and get points associated with the local ownership. The question for some of the other participants of AIM, what's the value of that local ownership of the total? Is it 20% of the total for that category? Is it 5% of the total? And that is something that staff is going to circle back internally and provide a response to the value of that local ownership as far as the scoring component. So example, let's say you could score a 95, someone scores a 95% or a 98% because they have that local ownership. But if you don't have a local ownership, does that mean the best you can do is 95? In competing with that person, you may be at a competitive disadvantage, which I think is what Courtney was addressing there. And I think that's a legitimate concern of other processes that have incorporated that, where staff will go back and get a clarity to that and provide that to you in the Q&As.
Great. Also, the other question was, will there be a rubric for the scoring system?
So in the final evaluation, there was to identify all the key components of that based on input and provided by staff of the type of activity of which is more emphasis than others for that. What you have is the breakdown of each section of the total points allotted for that and identifying the different criteria that we're looking for, but the weight of the specifics. So there's 5 categories in a section, how much points is being identified there. is not something that we divulge for the purposes of the final Rubik's scoring.
Great. Thank you very much for your time.
You're welcome.
The next speaker is Karmisha Gorman.
Hi there.
We can hear you.
Okay, thank you. My first question is, if an application has areas that need to be cured and those areas are not corrected, is part of the initial fee refundable, or is the application pushed into the evaluation process? And my second question is, will the city be disclosing how many applicants have been received and are being processed?
So the answer to the first part of your question is that once you submit that deposit, that covers all the initial costs of the development of the program, staff reviewing it, and whatever needs to be done up to that point. So it would not be refundable if you can't cure it, because that is the fees associated with that first part of the application. So it will not be refunded. It's a non-refundable component of there. Regarding the disclosure of the applicant, so when the process closes, the city could consider of just saying, here's all the applicants and here's the locations for those applications that might be provided, so they're going to be asked anyway. Anything above that will not be provided until they gets to the public hearing process, where phases 1, 2, and 3 have been completed, or I'll say 3A for the purposes of, you know, what's being still scored. And the purposes of that is divulging any information that may put a applicant at a disadvantage or an advantage to another applicant while it's still being, a process is going on, would be inappropriate to do that at a time. So there won't be any information provided to you other than location, business name, and ownership of that app or that application.
Okay, and really quickly, at what point can you pause? I mean, up until what point can you pause it? Can you pause your application?
You say pause your application. So once you submit the application, then it's accepted and the payment is made. When you submit that check in that, if the staff has started reviewing it or doing their due diligence in it at that time, that's non-refundable.
Oh, I see. Okay.
Is that what you're saying? Yeah.
Yeah. Okay. That's clearer to me. And yeah, thank you very much for answering my questions.
You're welcome.
Next is Christina Cohen. Christina, you're unmuted.
Hi, good afternoon. Thank you all for your time today. We really appreciate all the information. I have just a couple quick questions about the breakup of the coastal zone versus non-coastal zone application periods. I wondered if there was a current projected timeline for the second application opening for coastal zone applicants, and if the non-coastal zone locations will be allowed to be permitted to be opened before the coastal zone locations are allowed to be open.
I think I can take the first shot at that. I think the second part of your question, the applications for round 1 are not dependent on anything outside of round 1. So you go through the round 1 process and you get selected, you can move forward as you go through all of the requirements. As for the timeline for the coastal zone aspect, we believe we might have answers from the coastal zone in, I think, 6 months. Coastal zone, the coastal commission, I'm sorry. But we don't control their schedule. And so we have to go through their process to make the zoning rules apply to the coastal zone, and then we will launch a process for the remaining spots.
Thank you, Peter, Mr. Gilly. I do have one other question concerning the breakdown of the applications. has it been considered or discussed whether it's a competitive advantage for non-coastal applicants to go through the process, be scored, see how they're scored, and then be allowed to apply for a coastal zone permit as well? They're essentially going through the process twice, is my understanding, or would be allowed to.
Sure. So as we mentioned at the beginning of the process, if you go through the first process and you are not awarded a permit, you're still eligible for phase 2 in the coastal process. So of course, you're going to pay the fees to go through that, then get awarded. That still makes you eligible for the second process as long as you're not awarded a permit.
But are the applicants who are not awarded allowed to see their scoring?
They will just see the total score. Matt, you want to touch on this?
We need to talk to the city to determine exactly what is going to be released at what phase. That hasn't been determined yet.
Thank you, Mr. Eaton.
Okay.
I think that's all my questions addressed for now. I appreciate your time.
Thank you. Our next speaker is Aaron Herzberg.
Hello, can you hear me now?
Aaron, we can hear you.
Okay, great. Thank you so much. So I wanted to focus on section F, and specifically item number 5, which appears to be fairly redundant or duplicative with section H. So section F, subsection 5, talks about providing information about the location, the physical address, a description of the location, overall property building interior plan, photograph, site and building, and things like that. And then section H also says a thorough narrative description of the location, including but not limited to the site, overall site, proposed buildings, etc. And then it also asks for photographs of the building and the site, various vantage points. So I guess what I'm sort of asking for is if you could provide any color or explanation or maybe clarify that redundancy. When responding to this, should we basically reference like from one section to the other and say we answered this previously, or is there any, can you give a little bit of color as to why the redundancy?
Yes. So we understand that there are some redundancies. The reason for that is that there will be different set of eyes examining and looking at the different sections for a variety of different reasons. So even though there appears to be some redundancies, it is important for you to respond to each section. It is very important that you put the exact information that is asked for in the appropriate section. So one, you get scored, but the people that are looking for very specific information can find it where they're looking for it at.
And so the other part of that, Aaron, would be is that, what you put on writing and then what you discuss in the interview panel needs that information to have a better understanding, or more intimate, because it'll be the staff, the selection committee that will do their research and be more intimate to the location and understanding as you go through the interview of how you address those things. So they need kind of both. And as Matt said, some of it might be redundant, but one's looking at different things on, I think, Matt, you talked about one's more focused internally and one are out on the security plan. It's kind of similar to addressing what's asked in section F versus section H.
As far as the photos, can we just attach those photos perhaps as exhibits and reference to those? Because it seems like you're asking for the same exact photos twice. And so, that's my only thought on that. Do you really want the same exact photos 2 times? But whatever, I appreciate the answer. Nice to talk to you, David and Matthew.
Thank you.
Sorry, we will, let's talk about that, and we can put in the FAQs a response to the photo issue.
The next speaker is James Rushing. James, you're unmuted.
Thank you. Thanks everybody for taking my questions. I had a list of questions, but it seems we've knocked several of them out, which is good. I had a question, one about maybe more about the ordinance itself than the RFP. It's is retail locations allowed to do delivery in the city limits? What is the rules and regulations in the city with in regards to retail being able to deliver the product out of there? I did see some language in the ordinance that I didn't quite understand. And then the second question I had was, you know, the soft buffers zones with, you know, passing of travel for school. If it seems here on the application that if we are able to explain that we're doing the best that we possibly can, and we are able to, you know, come up with some really great ideas for limiting exposure of you know, walking pedestrian path of travel, would that get us the full points, or is there a risk of the fact that even if we did the best we can do, the fact that our location may be within that path, that there's a risk of losing points just for location? That's my 2 questions. So delivery and that path of travel.
I can go ahead and answer the first question. Retailers or licensed retailers in the city will be able to conduct deliveries as long as they comply with all of the delivery requirements in chapter 6.420 as well. So they will have to obtain a separate cannabis delivery service permit, which doesn't have the same restrictions as the commercial cannabis businesses located within the city. So it is an easier process to obtain that permit.
And the sensitive use buffers, you know, doing the best we can, does that get us the full points, provided that the city determines that those efforts are worthwhile and really the best efforts that the group can provide?
So part of looking at it is kind of a 3-page approach to that. One is on the scoring component of the application. It's really identifying the issue, coming up with the solution for the issue, and recognizing what the issue is. And that'll improve your chance of maximizing or, you know, getting the points where to improve your position on those. That's in the written part, though. The interview part, it's how you're going to present that information to the panel and their experience of the issues with that location and any policy issues of concern that come out of that. So you could score and maximize that, but you also still have the public hearing part too that comes into play of that final decision, where the city manager has full discretion in evaluating all the totality of everything to address the concerns of council. And, you know, it's hard to give a heart of where that is because we don't know the locations. It's how you have the locations where then there's more information to address the concerns of that. But in short, yes, you could maximize the points if you do a bang up job and you've done and addressed everything to the degree where it satisfies the different phases of the process.
Okay, I appreciate the answer. It was very good.
The last speaker is Casey Dalton. And it looks like we may have lost them. They're no longer listed on the attendee list. I'm sure he can contact Yesenia if he has additional questions.
All right, is that it with the questions? No more?
That completes our public speakers, our public speakers, sorry. Yes, that completes our speakers.
Okay. So it looks like we have about 5 or 6 key questions that we need to provide a response to, that we'll circle back with staff and provide them to you. Staff, Peter, Megan, do we have like an estimated timeline that we can share with them as far as where we think we can get those posted or presented to them? I know the application process is not technically open yet, so we have a little bit of time to respond to those, but any thoughts on that?
I am actually currently taking a look at calendars, and we will try to get something scheduled early next week for us to meet internally to discuss those and hopefully have some responses posted by the end of next week. I think it's a reasonable timeline for that.
Okay.
I apologize. I've had 2 other people inquiring if they could ask additional questions. Do you want to take those? Okay.
More than happy to.
Let's see, Courtney Karen. Courtney, you're unmuted.
All right, thanks so much. Just one follow-up question. David, earlier in the presentation, you mentioned that points are awarded for meeting the criteria that is listed in the actual application. In other merit-based application processes that were scored by HDL, specifically Oxnard, clients were deducted points for not exceeding the minimum requirement that was presented in the criteria. And so that leads me to a question of having a better understanding of whether full points are given for simply answering the question, or if the only way that you can truly achieve full points is by actually exceeding what the minimum requirement is. And that's just specifically based off of points that were deducted and the reason for those points being deducted in prior application processes.
Sure. So maybe how I wordsmith that was not appropriate, but I'll ask Matt to maybe respond to that and how it's actually evaluated.
Yeah. So the assumption is going to be that the applicant provides us everything that is asked for, and the approach will be a deduction of points for any information that is unclear, that is found in the wrong section, or does not accurately respond to the question or criteria that is being scored. Does that answer your question?
Sort of. I mean, in this specific instance, the note that was put in the documentation was related to safety plan. And it said in there, while the minimum criteria has been met, for maximum points, applicant should have exceeded the minimum standard, as top scoring applicants were deemed to have exceeded the minimum standard. And I have just a little bit of struggle with that type of language, specifically because no one really has any way of knowing whether or not they have met the minimum standard or they have exceeded the standard, when we're only given one standard, by which to write an application, and that is described in the application materials itself. So I just wasn't sure if there was any form of clarity that could be described for applicants to help them understand whether they're going to receive maximum points for simply answering the questions described, or if they're somehow needing to exceed the questions described in order to receive the maximum points. I realize that's not as clear, but that's like the clearest way that I can probably state it. And this occurred on, probably the top 5 applicants in Oxnard all had this at least once come up on their application scores. And so that's why I'm trying to figure out how to prevent, obviously, this from occurring again.
Yeah, so the approach to the scoring is different than Oxnard. It is not the same. And your response, if it is complete, will be awarded the full points.
Thanks so much, Matt.
Okay, and Sam Kojak has another question. Sam, you're unmuted.
Thank you for today's meeting. My question is back to the 51% ownership interest for the local preference owners. Would a business owner in the city of Ventura qualify as well as a resident for that qualification?
David, you're muted.
Okay. Peter, that specific question, can we bring it up and see how we've worded it?
Can you tell me which page it's on?
Owner, is it in the owner? The question, who's asking the question, what section are we referring to specifically?
Specifically the ownership acknowledgement form, which has the 51% ownership interest. And I think the question came up a couple of times already on the call. The question is, part of the 51%, could a business owner who's been in Ventura, City of Ventura, for many, many years qualify as a local?
So we go to the appendix. I think it's referring to the ownership in the appendix, Peter. So when it talks about the ownership, it's in the ownership qualifications.
Do you know what section that's in?
Oh, I think it's isn't it not F, it's G. Go down, just keep going down. Location, community, too far neighborhood.
It's not proposed, it's not this. No. There it is. Ownership team.
Ownership team.
So that 51% does not show up as the evaluation score criteria in the Appendix A. It's a requirement in the letter or that waiver. I'm sorry, that document. And that document is not a scored criteria.
Okay, so, but don't we have what a local owner on here? That's what I was trying to look on what we put on here.
I believe it's section B8.
B8?
Yes, I think so.
Okay, so it says here, describe to the extent to which the cannabis business will be locally owned enterprise and the owners reside within the city of Ventura. So there in itself says the owners reside. So it has to not, where we've had some cities that have allowed either reside or own a business in the city. The council made a decision on this purpose, that must reside in the city. So to answer your question, owning a business would not qualify for that criteria. You must reside in the city. The other part of the question is we're determining a second part of this, which we're going to come back to in the Q&A.
Clarity.
Does that answer your question?
It does.
Okay, thank you.
Okay, that looks like we're finished with the questions.
Okay, so before we go off, I think Matt's comment about, and I think the issue on the 51% ownership, the 51% ownership is really what defines the local preference is different. That's just a determining what qualifies you as a few of the participants have alluded to Oxnard. Oxnard used a 40%. Some cities use a 20%, but the determination of showing that local ownership for the purpose of local ownership is 51%. it doesn't mean that the scoring criteria is going to reflect that. That's just to make sure people don't manipulate what defines as the local owner. So that document, as Matt mentioned, is separate from what's going to be scored on what points will be awarded for a local ownership of that total points. And that is where internal staff will make that determination, get direction internally, and then provide, what percentage or how that impacts that section of the category when that is done. So I just want to make sure that was clear. And with that, I guess, unless we have any other questions, we are done. We appreciate everyone's time. I'll pause there. Nothing else? Okay. Again, review everything in the documents in entirety. Follow up with Yesenia to the email or contact information if you have any questions, and we'll try to respond to any additional questions as they come in. Timely manner, as Megan had indicated, depending on the complexity of it and who's got to respond. But the initial questions we have here, she's provided you that hopefully by next Friday, those will be posted. And with that, thank everyone for their time, and we wish you the best. Thank you.